Good afternoon, everyone. Thanks for joining us here. My name is Pam Wanzel. I'm the Director of Pro Bono at Frederickson and Byron, and we're just really excited to start hosting this summer series for our very, very good Pro Bono partner, Advocates for Human Rights. I just want to go over a couple things. This presentation is being recorded, so if you could check your phones for me, turn them on vibrate or silent, we would appreciate it. If you do need to make a phone call or you get something and you want to do some work, there is a visitor office and room right at the end of the hall. Restrooms are right down the hall here. And there is a sign that says reception area. So you just go, make sure you go out that door, otherwise you'll get turned around. Anything else I need to tell them? Restrooms I just did. Yep, okay, so plenty of food, help yourself. Otherwise, I want to introduce Theresa Dykoschak. Was I close?
Yes.
All right. With the last name with Wanzel, I always want to make sure I pronounce everything correctly. So anyway, thank you all. Please feel free to ask questions and enjoy the presentation. Thank you. Thanks, honey.
Thank you very much. And first, thank you to Frederickson and Byron for hosting the Women's Human Rights Speaker Series this summer. We'll be back both on July 14th and on August 2nd, so you can register for those sessions through our website, theadvocatesforhumanrights.org. Also, thank you to all of you for attending today's session. Many of my colleagues from the Advocates for Human Rights are in the audience, so we'll open it up for questions at the end, and I welcome their contributions as well. We do have a lot of ground to cover, so let's get started. So first, we'll do a quick overview of our organization, the Advocates for Human Rights. The Advocates for Human Rights, it was founded in 1983 by a group of Minnesota attorneys. Our mission is to implement international human rights standards to promote civil society and reinforce the rule of law. We currently do this through 4 programs: International Justice, Refugee and Immigrant Program, the Research, Education, and Advocacy Program, and the program that I'm a part of, the Women's Human Rights Program. I also want to note that we do have a school that's in the Sanku Palubari Valley in Nepal. Thankfully, our students, they were able to return to classes just a few weeks after the earthquakes hit Nepal last year, and the school is currently being rebuilt. Specifically in the Women's Human Rights Program, we've been carrying out international legal reform on women's human rights for more than 20 years. We have worked with partner non-governmental organizations in more than 40 countries, primarily in the region of Central and Eastern Europe and the former Soviet Union. And we work to develop and implement domestic violence legislation, and we work locally with respect to sex trafficking. When we began this work 20 years ago, none of the countries in that region had domestic violence laws. Now most do, and the Advocates for Human Rights has been involved in helping them pass, implement, and improve legislation. We do this in 4 different ways. First, our partners may ask us to come and do a monitoring report on how their laws are being implemented, how well they're working. We identify gaps as well as good practices, and we provide them with recommendations on how countries can improve their responses. We've published 25 such reports over the past 20 years, and we have 2 more reports that we'll publish this year. Second, we provide education both locally and internationally on women's human rights issues. Locally, for example, we train with respect to the implementation on Minnesota's safe harbor law. And internationally, we train police, judges, prosecutors, and others to ensure that the people who are charged with enforcing the laws, that they understand their obligations and how to carry out those obligations. Third, we may advocate to parliaments or legislatures to get a law in place or to get an amendment passed. And we also advocate at the United Nations through the mechanisms that we'll talk about today to put international pressure on countries to change laws and practices. And finally, we're often asked to review draft laws or amendments to laws, and we provide recommendations according to internationally accepted best practices. So I wanted to start with this quote from Hillary Rodham Clinton in Beijing in 1995. If there's one message that echoes forth from this conference, let it be that human rights are women's rights, and women's rights are human rights once and for all. I wanted to start with this not only because it was one of the motivations for this presentation today, but it also sets forth a really simple idea. And I'm going to ask you to keep that idea in mind throughout the presentation. Women's rights are human rights. Full stop. We're going to talk a lot about the human rights that have been acknowledged and agreed to from around the world, but this is a concept that needs to be reiterated over and over again because it still has not become our reality. But let's start with talking about what those rights are. First off, there's no way I would be able to cover all of the international and regional legal frameworks in great detail in an hour over lunch. So if you came to the presentation to watch me attempt to do so, I'm sorry. I can speak quickly, but not that quickly. So we're going to do a high-level overview of the frameworks and focusing specifically on violence against women. But I'm happy to continue discussions afterwards with anyone who is interested. So starting with the international frameworks, and when I'm referring to international frameworks, I'm referring to the United Nations system for purposes of this presentation. Specifically, we're going to focus on the United Nations Charter, United Nations human rights treaties, and the mechanisms that are implementing them and monitoring them, a couple of General Assembly declarations and resolutions, and a couple of other procedures under the Human Rights Council. There's a lot more that we can talk about, but again, we just have an hour together. And a couple of quick clarification notes. A lot of these are just terms that I'll be using throughout the presentation, so I wanted to explain what I meant before I start using them. So I'll be referencing both binding and non-binding instruments in the presentation. The binding instruments that I'm referring to are treaties. So these are formal written agreements between and among countries, or capital S states, I'll be using that term a lot too, capital S states, where they have to take steps to consent to be bound by the treaty through either ratification or accession. They then have obligations to comply with the treaties unless they've included a reservation when they acceded to or ratified the treaty that excludes or modifies particular rights as part of that treaty. And often United Nations human rights treaties, they're followed by optional protocols, which provide for treaty procedure or they address a specific issue underneath the treaty. These optional protocols, they're treaties themselves, so countries have to ratify or accede to them. And one example of one of these treaties that we'll be talking about today is the International Covenant on Civil and Political Rights. And that has two optional protocols. The first one establishes a complaint mechanism where individuals can submit complaints to the committee that's monitoring the treaty. And then the second optional protocol addresses the abolition of the death penalty. So it covers both a procedure and also a substantive issue. And non-binding instruments, they're pretty much the exact opposite of the binding instruments. These are non-binding. The state doesn't have a legal obligation to do something, but these are recommendations on what to do. So starting at the beginning, 1945, the creation of the United Nations right after World War II. This quote is from the preamble to the United Nations Charter, which is a binding instrument. We, the peoples of the United Nations, determined to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and of nations large and small. In addition to the language in this preamble, Article 1 of the United Nations Charter, it states that one of the purposes of the United Nations is to promote respect for human rights and for fundamental freedoms, without distinction as to sex or other qualifications. So even from the beginning, the United Nations is recognizing equality between the sexes in the recognition of their human rights. So what are these rights? We have the United Nations Charter that acknowledges that men and women both have equal access to these rights, but it doesn't enumerate them. There was discussion at the time of drafting the Charter, but there wasn't enough time to consider this Bill of Rights at that point. But many considered the creation of an international Bill of Rights as being basically implicit in the United Nations Charter. And there were some disagreements about the form that this International Bill of Rights should take. I see Emily nodding in the back. So the drafting committee, they started out preparing two documents. They started with a declaration that set forth these general principles, and the second document, it was a convention that would identify these specific rights and their limitations. These became collectively known as the International Bill of Rights. The declaration, it was reviewed first, and again, there wasn't time to consider the covenant or how the covenant might be implemented. So the declaration was the first part of the International Bill of Human Rights to be adopted, and it was adopted by the General Assembly in 1948. Making a long story short, The General Assembly, they initially decided to include civil, political, economic, social, and cultural rights all in one covenant because they're all interconnected and interdependent. But after debate, it went back and requested the drafters to create two separate documents, one that contained civil and political rights and one with economic, social, and cultural rights. The two covenants, as we'll see, though, they contain many similar provisions. And an article and by-article discussion of these covenants began in 1955, but it wasn't concluded until 1966, when both of the covenants were opened for signature. Am I speaking too quickly? Okay. Thanks. So what rights do these instruments contain? We'll start with the Universal Declaration of Human Rights, and this is a non-binding document. And hopefully everyone recognizes Eleanor Roosevelt from 1948. So the Universal Declaration for Human Rights, it provides for equal entitlement to the rights listed without distinction of any kind, including based on sex. A few examples of these rights that are relevant to women. All human beings are born free and equal in dignity and rights. They're entitled to life, liberty, and security of person, recognition before and equal protection of the law, equal rights as to marriage, during the marriage, and at its dissolution, the right to own property, the right to work and equal pay for equal work, the right to an adequate standard of living, and the right to education. The Covenant on Civil and Political Rights, it contains similar rights, but as a covenant, it's legally binding on the states that have ratified or acceded to it. Again, it recognizes that men and women have equal rights to enjoy all of the rights set forth in the covenant, and that the states, the parties to this covenant, they undertake to adopt laws or other measures to give effect to the rights and promote effective remedies when these rights and freedoms are violated. These rights include the right to life, liberty, and security of person, the prohibition of slavery, equality before the law, equal protection of the law, equality before courts and tribunals, and equality of rights and responsibilities as spouses in the marriage, during the marriage, and at its dissolution. The ICCPR, it opened for signature in 1966, but it didn't enter into force until 1976. This map here, it shows all of the states parties in dark blue, so the states that have ratified or acceded to the convention. There are currently 168 states parties, including the United States, and there are 7 signatories. So these are countries that have signed the covenant, but they haven't taken the steps to ratify or accede to it. And there are 22 states that haven't taken any action. Similarly, the Covenant on Economic, Social, and Cultural Rights, it contains rights that sound familiar from the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. And it's legally binding on the states that have ratified or acceded to it. Once again, men and women equally enjoy the rights set forth in the covenant, and states are to undertake steps to the maximum of available resources to progressively achieve the full realization of the rights, including through adoption of legislative measures. These rights, under the ICE-SCR, they include the right to work, including women being guaranteed conditions of work that are not inferior to those enjoyed by men, with equal pay for equal work, marriage being entered into with free consent, special protections being provided to mothers, and working mothers being accorded paid leave or leave with adequate Social Security benefits, and also the right to education. Again, the map shows the states parties in dark blue. For this covenant, there are 164 states parties. There are 6 signatories. The United States has signed this covenant, but we have not ratified it. And there are 27 countries that have not taken any action. So we have the International Bill of Human Rights that sets forth a pretty good list of the rights and recognizes that they're enjoyed equally between men and women. So that should be okay, right? Well, in 1967, so even before the ICCPR and the ICE-SCR entered into force in 1976, the United Nations General Assembly recognized that even with the United Nations Charter, the Universal Declaration of Human Rights, the international covenants, and other instruments, there's still considerable discrimination against women. So they prepared the Declaration on the Elimination of Discrimination Against Women, which recognized that it is necessary to ensure the universal recognition in law and in fact of the principle of equality of men and women. The Declaration stated that states should take measures to abolish existing laws, customs, regulations, and practices that are discriminatory against women and establish adequate legal protection for equal rights of men and women. They should put the principle of equality into their constitution or other legislation, and also ratify or accede to the United Nations instruments as soon as practicable. But this was a non-binding instrument. But after efforts from the Commission on the Status of Women and other international efforts, we have the Convention on the Elimination of All Forms of Discrimination Against Women, and this is a binding instrument. The convention, it covers both civil and political rights, and also economic, social, and cultural rights. It also pays particular attention to specific phenomena such as trafficking or to certain groups of women like rural women, and to specific matters where there are specific risks of women's full enjoyment of their human rights, for example, during marriage and related to the family. Article 2 of the convention, it requires states parties to take all appropriate measures to eliminate discrimination against women by any person, organization, or enterprise. It also includes language addressing specific forms of violence against women, including trafficking and forced marriage. There are a high number of reservations, though, for the states parties that have ratified or acceded to CEDAW. So in these high number of reservations, it does affect the impact of the treaty. The General Assembly opened the treaty for ratification, or for signature, in 1979, and it entered into force in 1981. And as you can see by this map, there is strong international participation. There are 189 states that are parties to CEDAW, and 6 states that have not ratified it. And as you can see, once again, the United States, we have not ratified CEDAW. We're a signatory to it and have been since 1980, I believe. And there are 5 other states that have also not ratified CEDAW. But there's something missing from the language of the convention. Although it may reference specific forms of violence against women, it doesn't contain a general statement that addresses violence against women. And in fact, none of the core human rights instruments contain an explicit statement that addresses violence against women. But the committee that was established to monitor the CEDAW Convention, it actually changed that in one of its general recommendations. And general recommendations are statements from the committee that are the committee's interpretation on the language of the convention. So although it's a non-binding recommendation, the committee in 1992, it stated that gender-based violence, which impairs or nullifies the enjoyment by women of human rights and fundamental freedoms under general international law or under human rights conventions, it's discrimination. In other words, gender-based violence is covered and prohibited by the convention. This was groundbreaking at the time because it was the first time that a treaty body had interpreted a treaty to explicitly prohibit violence against women, and that was 1992. And I wanted to briefly talk about one additional human rights treaty that's been used with respect to women's human rights, specifically violence against women. The Convention Against Torture, it was adopted in 1984, and it entered into force in 1987, so before the CEDAW Committee's recommendation with respect to gender-based violence. The Convention Against Torture, it defines torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted by a person, on a person, for such purposes as intimidating or coercing him or a third person, or for any reason based on discrimination of any kind. But the definition states that these acts are at the instigation of a state actor. And as we know, many forms of violence against women, they're not at the instigation of a state actor, they're actually instigated by private individuals, private persons. But again, the committee that's responsible for monitoring the implementation of the Convention Against Torture, it recognized in one of its general comments that women are at risk of torture or ill treatment, including through the deprivation of liberty, medical treatment, particularly involving reproductive decisions, and violence by private actors in communities and homes. And in that same general comment, the committee clarified that where state authorities or others acting in an official capacity or under color of law, if they know or have reasonable grounds to know or believe that acts of torture or ill treatment are being committed by non-state officials or private actors, and they, the state, fail to exercise due diligence to prevent, investigate, prosecute, and punish non-state actors or private actors, the state bears responsibility, and its officials should be considered complicit and otherwise responsible under the Convention. So that's an important concept when we're talking about violence against women issues, because it can make states accountable for violations of rights when these violations are made by private, not just state actors. And the Committee Against Torture, it's not the only treaty body committee that has applied this principle, and we'll see it stated even more directly at the regional level. So even with all of these international treaties, in 1993, the General Assembly, it recognized the urgent need for the universal application of the rights and principles with regard to equality, security, liberty, integrity, and dignity of all human beings. Noting that these rights and principles, they're already enshrined in the Universal Declaration of Human Rights, the ICCPR, the ICE-SCR, CEDAW, and CAT, they also acknowledge concern about the long-standing failure to protect and promote rights and freedoms in the case of violence against women. The Declaration also reiterated that women are entitled to the equal enjoyment and protection of all human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. And this declaration from 1993, it filled a major gap in international law because it actually included a specific definition of violence against women. But unlike how the Declaration on the Elimination of Discrimination Against Women, it led to the Convention on the Elimination of Discrimination Against Women. I should really start using the acronyms. This particular Declaration on the Elimination of Violence Against Women, it actually has not resulted in a binding treaty at the international level relating to violence against women. So we've discussed some of the rights that exist under international law, but let's also talk about how states are monitored to ensure that they're complying with their obligations under these treaties and these conventions. So there are committees that monitor the implementation of the conventions, and there are 3 different ways that they can look at states parties. So first, periodic reporting. Every 4 to 5 years, states undergo a review by the committee of the convention that they've ratified or acceded to. The committee reviews their progress and provides them with recommendations on ways that they can improve their responses to complying with the convention. Notably, other United Nations entities and non-governmental organizations were able to participate in this process. And so we can provide information to these committees, invaluable information to these committees, on how these countries may not be complying with their obligations. Second, several committees, they're able to receive complaints against a state party from an individual or a group of individuals because they're based on a complaint that their rights have been violated. And importantly, this procedure is not available unless a state party has specifically ratified either the convention or the optional protocol that contains the mechanism that establishes this complaint process. And also the complainant or complainants, they also must have exhausted their domestic remedies, so they must have gone through the judicial system and the courts of the country where they're coming from. So it can be a long process when you're approaching the United Nations with these complaints. We'll talk about a couple of examples, though, of the impact that these complaint procedures can have. And then finally, some of the committees have an inquiry procedure. These are investigations conducted by the committee if they've received reliable information on serious, grave, or systematic violations by a state party. Again, these are only available to the states that have ratified the particular convention or the optional protocol that contains this procedure. They're also less commonly used. For example, the CEDAW committee, they have only published 3 inquiries involving Mexico, the Philippines, and Canada, and those inquiries took several years. And again, note that these mechanisms, the committee-based mechanisms, they are recommendations, so they're non-binding. But let's talk about a couple of examples of state responses through these complaint procedures. In 2 cases from 2005, that were against Austria, and the plaintiffs' names were Gecki and Yildirim. They involved the murders of 2 victims of domestic violence by their husbands. Both of these women had been subjected to years of abuse by their husbands, even though they had reported the abuse to the police, and they had protection orders against them. The committee determined that Austria had violated its obligations because authorities knew or should have known of the dangerous situation that these women were in. But because the Austrian authorities, they were not acting with due diligence, the husbands were allowed to act with impunity. The committee's recommendations, including strengthening Austria's implementation and monitoring of criminal laws, and prosecuting perpetrators in a speedy manner, among others. They quickly responded with increases in funding for intervention centers for victims of domestic violence and their families, making changes in its criminal code, and granting victims the same rights in civil proceedings as in criminal proceedings. And by 2007, when Austria underwent its periodic review, the CEDAW committee was actually commending Austria on its responses. And then another positive example, a slightly more recent one, it's been with Bulgaria. And in Yalo versus Bulgaria, our Bulgarian partner actually represented the victim. In this case, Yalo was a woman. She was originally from Gambia, and she moved to Bulgaria. It's important to note that she didn't speak Bulgarian very well, so already keeping in mind the issues she might face in accessing the judicial systems. And her husband, he had been physically and sexually abusing her for years and wouldn't allow her to leave the house or find a job without his permission. The husband also abused their daughter. So the Child Protection Department showed up one day because he had actually contacted them to try to get her to stop breastfeeding their child. But when the Child Protection Department came, they recognized the domestic violence situation. And they advised her, oh, you should seek refuge. But then they didn't actually provide her with any ideas of when or where or how she could get away. And even without speaking to her, so the information with respect to the domestic violence, it did make its way to the prosecutors. But without contacting her or interviewing her, the prosecutors discontinued their investigations on the domestic violence, and they said that they just didn't have enough evidence. The police had also responded several times to the domestic violence against Yalo, but they only would give her husband a warning. They didn't arrest him. In other areas, her husband claiming that he and the daughter were actually the victims of domestic violence, he was able to obtain an emergency protective order against Yalo. The order was not translated for her, so she didn't know what it said, but it had evicted her from her house, and it also gave temporary custody to the husband. So the courts evaluated this. A permanent order was not entered, but the husband had appealed it. So for 8 months, she was waiting for this process to complete, and he maintained custody of her daughter, and she did not have any contact or access to her. He had also initiated divorce proceedings and continued to abuse Yalo during this period of time. She sought medical help, but was not able to get a medical certificate to document her injuries because of the cost. So the committee determined that Bulgaria had violated the convention because it failed to complete suitable and timely investigations relating to the prosecutors and the police, and it failed to protect her equality in marriage and as a parent. And it also observed that the authorities' responses were based on stereotypes of the husband's superiority. They were relying on his accounts with respect to the emergency protective order. The committee recommended compensation, and for the state to also take effective measures for victims of domestic violence, to have effective access to services and courts. And in 2015, the committee noted that the Bulgarian government had actually provided compensation to the victim, and they found satisfactory implementation of the recommendations. So I have two more, at the international level, we'll talk about two more mechanisms. And this first one, with respect to the Human Rights Council, if there are violations occurring in a country that hasn't ratified or acceded to a particular treaty, or if you're looking for another way to bring attention to violations of rights, the Universal Periodic Review Process, or UPR, it's a process under the Human Rights Council for reviewing the human rights record of all the United Nations member states. So it's going to cover all of the 193 members, and you don't actually have to be a party to a particular treaty or convention. This photo, it's a photo of the Human Rights Council room in Geneva, where this is all happening. Under the Universal Periodic Review process, states have an opportunity to declare the actions that they're taking to improve human rights conditions and meet their human rights obligations. And United Nations member states are actually reviewing their peers. So, for example, it would be Bulgaria providing recommendations to Austria on ways that they could be improving their human rights responses. But again, non-governmental organizations can participate in this process by providing information to the Universal Periodic Review Working Group and also lobbying to the other member states as they're preparing their recommendations to give to other countries. And the last one, I wanted to quickly talk about the Special Rapporteur on Violence Against Women, its causes and consequences. The Special Rapporteur can issue thematic reports and also country reports. She can make country visits and send communications to states regarding systemic concerns and responses to individual cases. You can send in individual petitions to the Special Rapporteur with respect to particular violations. She's been successful in bringing additional international attention to violence against women issues. But again, her country visits have to be approved by the state party, and her communications are also non-binding. Our current Special Rapporteur on Violence Against Women is Dr. Dubravka Simjonovic, and she just started her tenure last year. So a quick recap of the international framework and the instruments that we've talked about. So we have the International Bill of Rights starting in 1948 and the two covenants from 1966. Then we talked about the Declaration on the Elimination of Discrimination Against Women that recognized that there still is considerable discrimination against women and a need to ensure universal recognition of human rights, which then became the binding Convention on the Elimination of Discrimination Against Women. And we talked briefly about the Convention Against Torture and that concept of due diligence for states. And then this slide is a quick overview, continuing on from the Convention Against Torture. In 1992 and in 1993, we have these non-binding, the general recommendation from the CEDAW Committee, and then also the Declaration on the Elimination of Violence Against Women from 1993, also non-binding. I also wanted to point out the Beijing Declaration because that was from 1995, and that slide in the beginning with Hillary Clinton's photo, that actually, quote, was from this Beijing conference that took place in 1995, which resulted in the Beijing Declaration. And although it's not binding, there were 189 member states from the United Nations that announced their determination to prevent and eliminate all forms of violence against women and girls. So I wanted to pause before we move on to the regional frameworks to see if anyone has any questions at this point. It's a lot of information. Yes? The question was whether the United States has given a reason for ratifying CEDAW. I've heard varying explanations. One of them has been that we do have the laws in the United States that basically are parallel to what would be in the convention itself, so there isn't a need for an international convention for us. But then also it's related to, not wanting to sign on to another treaty and secede a little more of our sovereignty. Are there any other explanations that you guys have heard?
They have said that it's in their list of things, it's just not a top priority. It's down. They've said that there are other treaties that are ahead of the line.
Mm-hmm.
The argument that you just put forth is also an argument they use for why they do ratify treaties, so that's conflicting.
Mm-hmm.
But yeah, no, I think that's just not a good reason.
Yep. Yeah. And it has been considered, I think, 5 times by the Senate over the past 30 years, but it just hasn't been up for a vote yet.
There's majority to get approved by the Senate, so that's which is a tough actual.
There's concern that they trigger and open up U.S. obligations to women's rights, and you said that they don't agree to it.
Mm-hmm.
But I can have that share that with you or with the broader group.
All right. So on to the regional legal framework. So there are also treaties that have been adopted by 3 regional organizations: the Organization of American States, the Council of Europe, and the African Union. In addition to the general treaties that they have regarding human rights, each of these organizations has a treaty that directly addresses violence against women, and they have stronger language than the language that's in the treaties at the international level. It's important to note that there aren't any regional treaties currently relating to violence against women in Asia, so coverage would only be at a national or an international level or in a non-binding manner. So let's talk about 3 instruments from the Inter-American system. The American Declaration of the Rights and Duties of Man, which was adopted in 1948, it predates even the Universal Declaration of Human Rights from the United Nations. The American Declaration states that all men are born free and equal in dignity and in rights, and being endowed with by nature with reason and conscience, they should conduct themselves as brothers one to another. Despite the use of the word men, some of the enumerated rights within the Declaration are specific to women. For example, the Declaration calls for the right to protection for mothers and children. In addition, the rights enumerated in the Declaration, like the right to life, liberty, and personal security, equality before the law, education, and the right to own property, they use the word person instead of men. Although as a declaration it's not legally binding, the Inter-American Court of Human Rights, it has issued an advisory opinion indicating that this declaration is the text that's referenced in the Organization of American States Charter. And the Charter references that there are fundamental rights of the individual without distinction as to sex, among others. The second instrument, the American Convention on Human Rights, this was signed in 1969 and entered into force in 1978. And it articulates many rights, including the right to life, the right to humane treatment, the right to personal liberty and security, and the equality of rights, and also the adequate balancing of responsibilities of the spouses as to marriage, during the marriage, and in the event of its dissolution. Under the Convention, the states parties undertake to respect the rights and freedoms without any discrimination for several reasons, including sex, and that they'll enact laws and measures that are necessary to give effect to these rights and freedoms. The United States is currently the only member that signed but has not ratified the American Convention. And there are another two that withdrew their ratifications to the convention. So specifically, the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, also known as the Convention of Belém do Pará, it entered into force in 1994, and all but 2 members of the Organization of American States have ratified it, and those 2 members are Canada and the United States. This convention, it was the first binding instrument on a regional level, declaring that every woman has the right to be free from violence, whether in the public or in the private sphere. It was also the first human rights treaty on violence against women to impose an obligation on states parties to apply due diligence to prevent, investigate, and impose penalties for violence against women. So this due diligence principle is directly incorporated into the language of the treaty. Like the international system, there's a monitoring mechanism for the implementation of this treaty, but it's slightly different. States, in this case, they respond to questionnaires about the status of their implementation of the rights under the convention. And even before the Convention of Belém do Pará in 1994, these 3 regions, they were addressing violence against women issues in other ways, and these mechanisms still exist. So the Inter-American Commission on Human Rights, it was created back in 1959 by the Organization of American States. One of its roles is to examine petitions on violations under the American Declaration of the Rights and Duties of Man, as well as under the American Convention and the Convention of Belém do Pará. Since 1969, individuals, groups, and legally recognized non-governmental organizations, they've been able to lodge complaints for violations of the to the Commission. Like the commissions at the international level, or like the committees, at the international level, the commission's decisions are non-binding on the states. But if the state doesn't comply with the recommendations, or if one of the parties requests, and both of the parties, or the state party has actually acceded to the jurisdiction, the Inter-American Court can also take on these cases, and the Inter-American Court's decisions are binding, and there can also be monetary awards and also equitable remedies that can be granted by the Inter-American Court. So let's take a look at a couple of these cases from the Inter-American Commission and the Inter-American Court. So in 2001, the Inter-American Commission decided Maria da Penha versus Brazil. And in this case, she had been subjected to domestic violence for years by her husband, who shot her and left her paralyzed. His trial lasted more than 19 years, and at the end, he was given a prison sentence of 2 years. The commission determined that Brazil's failure to punish this violent perpetrator was a violation of the rights under the American Convention of Human Rights, her rights to a fair trial and to judicial protection, and also a violation of her rights under the Convention of Belém do Pará to live a life free from violence. Brazil now has a law that's unofficially known as the Maria da Penha Law, which emphasizes prevention, assistance, and protection for women and their dependents in facing violence. And it also establishes mechanisms for punishing perpetrators, including a dedicated domestic violence court. On the other hand, we have the United States' response to the Commission's recommendations in the 2008 case of Lenahan versus the United States. And the United States' responses were not quite as strong as Brazil's responses. In Lenahan, the petitioner was subjected to violence by her estranged husband. She had an order of protection against him that prohibited him from having access to their children. But when he took them, she repeatedly contacted the police in Colorado for help, and they didn't respond. The 3 girls were later found murdered by their father. Because the United States is not a party to either the American Convention of Human Rights or the Convention of Belém do Pará, the Commission applied the American Declaration on the Rights and Duties of Man. The Commission held that the United States government failed to act with due diligence to protect Lenahan and her children. The U.S. response was that it was not bound by treaties to which it was not a party or to non-binding instruments like the American Declaration. Although there's been limited relief provided to Lenahan personally, the U.S. did actually make broader changes that appear to relate to the Commission's recommendations, including investigating local police departments, and some jurisdictions have adopted resolutions that domestic violence is a human rights violation. In one of the most cited cases by the Inter-American Court of Human Rights, so now on the right side of the screen, it was a 2009 case that's also known as the Cottonfield case. And this related to 3 young women who disappeared in Ciudad Juarez in Mexico. The bodies of these young women were found weeks after their disappearance in a cotton field with signs of sexual violence and other physical abuse. The court found that Mexico had violated the American Convention and the Convention of Belém do Pará because it failed to act with due diligence in investigating their disappearances and murders. In its judgment, the court included 15 separate remedies, 14 of which were injunctive, and included directives for systematic changes. Mexico complied with some of the court's judgment, but has not yet complied with critical portions of the judgment that would impact Mexico's systems of investigating gender-based crimes. And even though these mechanisms to enforce human rights, they still exist, and by the examples that we just discussed, you can see the impact of using these mechanisms to actually enact changes by the state's parties. The Inter-American Commission recently had to suspend all of its hearings, and it was actually just last month in May of 2016 because of a lack of funding, and it's expected to lose 40% of its staff as a result. Moving to Europe, and the Convention for the Protection of Human Rights and Fundamental Freedoms. This convention is better known as the European Convention of Human Rights. It addresses relevant rights and freedoms, including the right to life, liberty, and security, prohibition of slavery and forced labor, prohibition of torture or inhuman or degrading treatment, the right to a fair trial, the right to respect for private or family life, the right to an effective remedy, and the prohibition of discrimination, including on the basis of sex. The convention opened for signature in 1950 and entered into force in 1953. And all 47 member states of the Council of Europe are parties to the convention. I think I need to speed up a little bit. So similar to the regional system in the Americas, in Europe there also is a court that's addressing human rights issues. Since 1959, the European Court of Human Rights, it's ruled on individual and state applications based on violations of the European Convention for Human Rights. Although the European Convention, it doesn't include provisions that specifically relate to violence against women, the ECHR, the European Court, it's issued more than 40 decisions relating to these issues, and its decisions are binding, and they can also include monetary awards. And I was going to speak about both OPAs and the case against Lithuania, but I think I'll focus on the case against Lithuania just to move things along so we can get through everything. So this 2013 case, it reflects these developments that have been happening at the European Court of Human Rights with respect to the court's understanding of violence against women. In this case, the applicant had been subjected to abuse by her live-in partner. She filed a private prosecution action, which the public prosecutor did not pick up. And then she went back and filed another one. And this time, it also was not picked up, but it was because it had been time barred. The European Court of Human Rights, though, however, when they were evaluating her complaint, they determined that the physical injuries that she had suffered as a result of domestic violence, combined with the psychological impact of the abuse, they were sufficient for a claim of torture under the European Convention of Human Rights. And even more, there's a fantastic concurring opinion from this case. Again, it's from 2013, but it indicates this growing understanding of the gendered nature of violence against women. And the judge in that case, he indicated that the full effect of the European Convention would not be achieved without a gender-sensitive interpretation and application of its provisions, which takes into account the factual inequalities between women and men and the way they impact on women's lives. And we certainly need to discuss the Istanbul Convention. This is the most recent of the 3 regional conventions that specifically relates to violence against women. And it actually just entered into force in August of 2014. So like the Convention of Belém de Pará, the Istanbul Convention, it explicitly states that women have the right to be free from violence. States need to take necessary actions to exercise due diligence, again, the due diligence principle, to prevent, investigate, punish, and provide reparation for acts of violence covered by the scope of this convention that are perpetrated by non-state actors. But unlike the Inter-American Convention, the Convention of Belém de Pará, the Istanbul Convention also draws heavily from the international framework. So there's a lot of influence of CEDAW and the communications from the CEDAW committee that you can see in the provisions of the Istanbul Convention. And it provides a lot of detail in the language of the convention relating to what states need to do, what steps they need to take to protect victims and hold offenders accountable, including the training of professionals, establishing shelters and hotlines, and enacting legislation that prohibits violent offenses that are specific to women. And again, there's a monitoring mechanism where states are subjected to a review of their implementation of the provisions of the convention. And let's also do a quick review of the instruments from the African Union. Several provisions of the African Charter on Human and People's Rights, they relate directly or indirectly to women's rights and violence against women. The Charter states that every individual shall be entitled to the enjoyment of the rights and freedoms recognized and guaranteed in the present Charter without distinction of any kind, such as sex. And the Charter also requires states parties to ensure the elimination of every discrimination against women and also ensure the protection of the rights of women and the child as stipulated in international declarations and conventions. The Charter is from 1981 and it entered into force in 1986. The Protocol to the African Charter on Human and People's Rights, it's also more commonly known as the Maputo Protocol. And this is the 3rd regional treaty that addresses violence against women. It entered into force in 2005. And it requires states to enact and implement legislation prohibiting violence against women. It doesn't contain a specific due diligence provision, but it directs states to adopt such measures as may be necessary to ensure the prevention, punishment, and eradication of all forms of violence against women, and states that every woman has the right to the recognition and protection of her human and legal rights. And it covers equality in marriage, access to justice and education, training and healthcare, and it also upholds women's property rights, inheritance rights, and several others. But there have been problems in the implementation of the Maputo Protocol. Only 36 of the 54 states of the African Union have actually ratified the convention. And even recently, the Special Rapporteur on the Rights of Women in Africa has identified that there's a lack of national laws that's having an impact on the implementation of this convention. And like there also is, similar to the Inter-American Commission, there also is an African Commission on Human and People's Rights. Again, these decisions are non-binding. There is an African Court on Human and People's Rights as well, whose decisions would be binding. The African Court began operations in 2006, but unfortunately they have not yet had a case that they've decided relating to violence against women. But one quick example, from 2013, there was a case at the African Commission of Human and People's Rights, and it was against Egypt. And it related to women who were assaulted at demonstrations that were related to Hosni Mubarak, who was the president of Egypt at the time. The commission found that in failing to protect these women who were attacked during these protests, that Egypt had violated their human rights, including the right to dignity and protection from cruel, inhuman, and degrading treatment. In addition to finding that the state failed to protect the women, the commission also found that the attacks were gender specific. But unfortunately, Egypt has not implemented the ruling at this time. So again, just a review of the regional timeline we've talked about. We have the declaration that began in 1948, and then we have the 3 binding conventions that applied to human rights generally, from the Council of Europe, the Organization of American States, and the African Charter. And then we also talked about the 3 binding conventions that are specific to violence against women from the Inter-American System, the Council of Europe, and also from the African Union System. And I wanted to conclude with just a couple of examples of ways that we've been able to use this international framework to affect changes. And the first one I wanted to talk about was advocacy that we've conducted in connection with Croatia. So in 2013, Croatia eliminated the article of its criminal code that was specific to domestic violence. Prosecutors could still use provisions that related to bodily injury or threats, but removing the domestic violence provision meant that many cases of long-term domestic violence were not going to be prosecuted. So joining with our partners at the Autonomous Women's House of Zagreb, in 2014 and 2015, we reported these problems to 3 different United Nations treaty bodies, and we also conducted advocacy in connection with the Universal Periodic Review process. And we helped our partner to actually present in-person testimony to the United Nations Human Rights Committee. And that pressure ended up paying off. In 2015, the Croatian government, they restored the specific offense of domestic violence to its criminal code. And one final example, in Mongolia, domestic violence had not been considered as a separate crime, and there were many barriers to prosecution of these offenses. And even in cases that resulted in severe physical injury, perpetrators weren't being prosecuted. We published a report in 2014 on the implementation of Mongolia's laws, and one of our priority recommendations was for the government to specifically criminalize domestic violence. After our report, we continued working with our partner organization, the National Center Against Violence in Mongolia, and we were submitting reports to both the CEDAW committee and also in the Universal Periodic Review process to push for international pressure for Mongolia to make these changes. And this past December, the Mongolian parliament amended its criminal code to finally classify domestic violence as a felony crime. And it's actually making further changes to laws as well. Does anyone have any questions? Comments or thoughts? Beatrice, Rose, any? Okay. Yes? Depends on under which framework. International framework, regional framework. We have not ratified any of the conventions that relate to the human rights or the specific to women's rights. At the international level, it would depend on under which convention or through the Universal Periodic Review process. But one of the fantastic things about our organization is that we work with so many volunteers in order to expand our resources and our ability to conduct advocacy. So we've had the opportunity to work with many volunteers on issues that are important to them and to the organization. So, yes.
So what is the effect really of being a signatory but not having ratified it?
It's a great question. So if you've ratified it, you have legal obligations, and you're subject to those periodic reviews, or you may have also ratified and be subject to the individual complaint mechanisms or inquiries. If you're a signatory, you don't have legal obligations, but signing it is an indication that you're going to comply with the spirit of the convention. But there isn't an enforcement mechanism or a monitoring mechanism. So, yeah.
How close to ratification did we get on the 3 times that
Oh, I'm not sure.
Pretty close, and it just wasn't, it's a higher bar, and we're able to get that past that point. And, initially, during the start of the Obama administration as well, there was a huge push and organization effort to sort of get it through at the beginning of his administration. And then it just got completely, sideswiped by other issues that these pieces or these, complaint mechanisms, it's the message overall.
Yeah, and we're inconsistent in our application of that as well, because we've ratified several of the conventions, but not all of them, so.
Exactly, so.
That there were,
For the recording.
sure. I noticed that in some of the provisions, there were mention of protecting cultural rights as well as women's rights. So where is the line between that? Because some cultures view women's rights differently than we may view women's rights.
So are you thinking specifically about the Covenant on Economic, Social, and Cultural Rights?
Yeah.
Yeah, and there are international standards that these women's rights, they're supposed to be enjoying these rights equally with respect to men and women. And if culture is going to be applied in order to discriminate against them from being able to exercise those rights, then that would supersede the cultural rights, the cultural situations.
I just want to add, oh, hello. Hi, sorry. Well, anyway, when it comes to the Convention on Economic, Social, and Cultural Rights, it has to do with the right to participate in cultural life. So it's a little bit different than your culture gets to use that as a validation for discrimination. It's nothing like, there's not like a situation where it's in conflict. It's that we want, just like freedom of religion, you have the freedom to participate in cultural life, but your cultural life doesn't usually, I mean, I don't know that there's any culture that defines itself by hitting people. You know what I'm saying? So in that sense, people use it as an argument, which, I mean, I hear that a lot of times when it comes to anthropological like ways of looking at cultures, and but the one thing about human rights that is very clear is that there are certain things that are okay and certain things that are not okay. And if you're not able to enjoy your life and you're not able to basically have all the rights that are enshrined in the Universal Declaration of Human Rights, it's a violation, period. And there's no justification, cultural or otherwise, that can override that.
Mm-hmm. And one of the interesting things, too, from the American Convention on Human Rights, and I didn't see this in the other conventions, that there actually is a recognition that your rights are actually, you also owe respect to other people's rights and the exercise of their rights, and that actually is specifically in the terms of the convention. So.
You said that the funding for the Americas regional courts is being cut. Is that funded by the ratifying countries, or how is it funded?
So it was for the Inter-American Commission, and so all of the Organization of American States, those members do make contributions for that would result in the funding of the commission. So it's not just those that have ratified particular conventions, but it's all of the OAS members. Any other questions?
CETA
Sure.
really quickly. So you're asking about our ratification of CETA, and one thing I like to share, even though the United States has not ratified CETA, we do have places in the U.S. that have just said we're not going to wait for the United States. For
Cities for
example,
CETA?
yeah, the city of, I think it's San Francisco, went ahead and just ratified it on their own and implemented it themselves, and then implemented laws to make sure that they could abide by the treaty. So as much as I agree with Bea, it is important to not have this exclusionary attitude that the United States shows. We can, as a place, say, well, we're going to push that agenda by just going ahead and doing it ourselves as a city, state, things like that. So we don't have to wait for the federal government. I would just add that.
And remember at the beginning when I said I wasn't going to be able to cover the entire framework in detail in over an hour, but thank you for adding that. Anyone else? Okay. Oh, sure. Oh,
Yep. If we were going to impact the system, what would be a logical access point to start at?
that is a great question, and it depends on what your particular interest is. I mean, there are ways to participate in both the international and regional systems, but it's also participation locally. You know, I was just focusing on the international and regional systems, but there are a lot of changes that we can enact in the United States that are national, state, and local regulations and laws as well. So it depends on what your interests are.
Who would be the group that would spearhead the ratification if it goes back to the Senate with the next president?
That's a great, I know that there are non-governmental organizations that have been advocating. There's like a CEDAW 2015 organization, and I'm assuming that they update their title every year.
There is that organization
So, yeah.
that you could Google and
Okay.
they change their name based on the year. And I don't know how active it is right now, but I'm guessing that they will be gearing up again.
Yeah.
Thank you.
Yeah, thanks. Oh, sure, yes, just a couple. As a reminder, we're going to be back for 2 more sessions of the Women's Human Rights Speaker Series. On July 14th, Beatrice will be speaking about sex trafficking, and on August 2nd, Rose Park will be speaking about the top 10 things that you need to know about domestic violence. You can register for those sessions on our website, theadvocatesforhumanrights.org, and also wanted to provide you with a couple of additional addresses. StopVAW.org is the Women's Human Rights Program website, and it contains a lot of information about various forms of violence against women, about international and regional legal structures, and about the implementation and the status of violence against women and other women's human rights issues in 34 different countries, mostly in Central and Eastern Europe. The last website I wanted to reference was we created the Justice and Legislation modules for the United Nations for UN Women, and those are available at endvawnow.org. So if you're interested in any additional information, there's lots of it out there. So thank you all very much.